David Shestokas is an attorney licensed in Illinois and Florida and author of Constitutional Soundbites. Dave also was on the ground in Pennsylvania during the tumultuous 2020 election ongoing coup attempt, first as a GOP election observer and then as an attorney assisting the Trump campaign. Dave Shestokas joins me now. Dave, welcome.
Thank you so much, Jason. It's great to be with you down under, I guess. So it's great to be with you guys down there.
Wonderful. Well, thank you. And we are certainly watching with all eyes on the case in the Trump matter. And we're seeing now that the competing cases are causing a real problem, not just for Trump attorneys, but for the system and for the perception of justice. What happens at this point with these competing cases here? Do you think this is part of the gamesmanship, knowing to put the ultimate amount of pressure on the former president as he fights his way towards the election of 2024, Dave?
I have to suggest that the matter that they have competing cases indicates the political nature of the prosecution more than the value of the prosecutions as actual criminal matters. But from that particular constitutional perspective, if you will, it's the defendant that is in fact entitled to both a fair and a speedy trial. But also, there's something in the Sixth Amendment of the United States Constitution relative to the right to counsel, and the courts have always found that it's right to counsel of your choice. And so that's another complication, because if President Trump has certain counsel that he wishes to work with, then he has the right to have them on each and every one of these cases. And so consequently, the courts are going to have to themselves get together and work this out so that so that his right to a fair trial is completed, and then his right to counsel and the counsel of his choice is met. If the courts don't get together to do that, they certainly risk of having any potential conviction overturned on appeal in regards to the fact that they would have violated the president's constitutional rights in that regard. And I would suggest that the Supreme Court would in fact overturn convictions from these kinds of pressures where the counsel was not able to properly prepare. I'm personally involved with another client in the Georgia case, and they have just told us to have a device that's capable of downloading 2 terabytes of discovery information just for the Georgia case. I don't even know how many millions of pages of actual documents that translates into, but 2 terabytes is at least 2 times the size of one of the best personal computers these days. So the ability to be able to pour through that, and then from that be able to put together our own requests for discovery and our own demands and our own motions, so that we can see to it that there's a fair trial. And that's just in Georgia, and that I know because I'm personally involved, but they indicate that there's millions of pages, about 12 million pages of documents involved in the Washington, D.C. case. And of course, we've got a separate problem with the Florida cases that the judges involved with, because generally speaking, the Constitution also requires a venue that the investigation and the charging of a crime take place in the venue where the crime took place. And right now, most of what was utilized to return the indictments in Florida were the grand jury work in Washington, D.C. So there are millions and millions of motions to be filed. I'll be real surprised, Jason, if any of this gets to trial, at least as far as the president's concerned, before the election. I would be very surprised. And also, there's the issue, of course. There's some civil matters apparently that the president is also involved in. Civil trials, the defendant doesn't necessarily have to be present. Certainly the defendant is entitled to be present, but doesn't necessarily have, as long as his counsel is there and presenting the cases. But in certain the state cases, Georgia and New York, it's pretty much mandatory that the defendant be present while those cases are going on. So there's his personal time, there's the lawyer situation, there's the discovery situation, there's the Fifth and Sixth Amendments involved. So I would suggest to you that this effort. Oh, and by the way, a couple of the Ms. Willis and I think Jack Smith have mentioned that they're interested in a speedy trial. The public should know that the right to a speedy trial only accrues to a defendant. The government has no right to a speedy trial. That right belongs to a defendant. And it's very, very sad to hear the prosecutors get in front of the press conference and misrepresent the law.
Dave, that is what we're expecting to see in all of this. It's this manipulation of the general public. It's the gaslighting of all of us that we're seeing over and over again. But it seems to have backfired. The sentiment's gone completely the other way now. Every time an indictment comes out, Trump's popularity improves, and a huge increase in his popularity resulted out of these Georgia indictments. You've got the black community there going the other way and saying things like, well, if they're going to indict Trump, he's now one of us. We're going to support. Do you take encouragement at this time that perhaps this whole trial really is a trial in the face of public opinion, regardless of what might happen in a courtroom?
I think that probably these prosecutors are miscalculating what they're expecting to do, expecting to achieve, or certainly what they're expecting to achieve really has got nothing to do with justice. It's got to do with interfering with the election. It's got to do with making it so President Trump is not a candidate, or is not a viable candidate, or is unable to run, or cutting that against him. But I believe the people of the United States of America are beginning to see what this is all about. And even those folks that may not support Donald Trump understand that people who do should have the right to vote for the man. And utilizing the legal system to try and abolish the right of somebody to vote for the candidate of their choice is certainly quintessentially un-American and largely unconstitutional. So I think the American people are beginning to see this. You mentioned that the polls regarding the minority community. I was on yesterday on a Chicago radio station. It's primarily a black radio station. In fact, we were on what was called the Black Excellence Hour, and we were talking about the Georgia case because I'm personally involved in that. And the comments that were coming through during the course of that interview were all in support of the president and against essentially the misuse of the government. Many folks in the minority community have felt that the government has personally been stepping on them for a long, long time. And I think they're beginning to identify with the misuse of government powers when it comes to President Trump.
Yeah. And Dave Shestokas, I thank you for your time today on World Series News.
Thank you, Jason, for having me.